any paper needed from the bank. I said to the judge, I said, this man over there, meaning the lawyer, who says he's a lawyer for the plaintiff, I said to her, he could be anybody walking off the street. That's why there needs to be a document stating he had permission from asset acceptance to be assigned the alleged debt from Chase Bank. Well, at that point, the judge again said nothing, and I started to realize to myself that the judge doesn't know what she's doing. I felt there was corruption involved here with the judge. The judge left the courtroom a total of 3 times, and I felt there was a conspiracy here in America by her leaving, getting advice what to do with someone like me. I now felt the pressure of not getting a neutral, fair, and honest judge.
Let me ask you this. Why did you become emotional now?
Because America means a lot to me. I look at other countries that don't have freedom, they're being killed. And the authorities, the government, the judges, not all of them, I don't know how many, are taking advantage of the American people. Were thousands of people that gave their lives at Gettysburg.
Millions. Right, 1 million, okay? And let me go on record now as to say, Kevin, there's people like you that motivate not only me, now, but I'm sure you're motivating Jim too, that you're motivating the camera crew in this whole room, the producers, the engineers. All we're asking of these guys is to read the rules, and this judge told you that she's going to be governed by the Pennsylvania Rules of Court. Now that you have first-hand witness account now, Kevin, that this is going on all over the United States. Every courtroom in the United States that I'm getting calls every day, Kevin. You're not the only one, okay? So, what happened next?
Well, I objected again to this according to Rule 319 and 37 because I thought stating the rule again, just reminding her what the rule says, that the lawyer cannot act as an advocate for the plaintiff at this trial.
That I received a letter, and it was filed in the York County Court, where the Supreme Court issued, and that's exactly what the Supreme Court said, Jim, if the defendant notifies the court that he or she will defend, that the plaintiff must be in court. It didn't say that the plaintiff may be in court.
Yeah.
Right? It didn't say, Jim, that the plaintiff might be in court. It says that you will be in court. Now we find Judge Heck made another major mistake. So what went on next?
Well, after I stated that again, that Rule 319 and 37 applies, the plaintiff must be there, the judge said to me, listen, based on Rule 207, I will allow this, and I don't have to follow all the rules in the rules of court.
Now, wait a minute. Wait. Now, Kevin, I'm sorry.
I understand.
Were you recording this? Did you take a recorder in with you?
No.
For your
No, I
rights?
asked her if there's going to be a transcript, and she says no. And she leaned over and said, don't you record it either.
She can't stop you from recording that.
Right. It's a
Rule
go on now. What did
1112D.
she say again now?
She said that based on Rule 207.
Yeah, but she don't have to follow all the rules of court.
Right. She was basically saying, don't keep bringing up 319 and 37. So right away, I'm just thinking common sense. I said, you mean, Judge, that Rule 207A1 is going to overrule 319 and 37? And she said, yes.
Yeah, she said yes.
Yes.
And right after she said, now, Jim, that I'm not following
I'd object,
all the
yeah.
rules here, that all I'm going to do is follow the rules that I can use to beat him, okay?
Yeah.
Yeah, what did you say then?
There wasn't much you could say because you realize at that point, no matter what you say, with the facts, this was a corrupt judge.
Corrupt judge.
You're thinking,
And
I know, you read in the newspaper and you see on TV, occasionally a judge or policeman getting indicted and going to jail. So I figured this was another one that wasn't caught yet.
Caught yet,
We
but
have-
she's caught now. That Alan's going to be on the show next, I think, where he had a judge, and I believe it or not, this judge was absolutely honest.
Oh, Judge Dunleavy.
Dunleavy.
I was there, I
Oh,
was
yeah?
witness to that, yes,
You
he
there?
was, yes.
If you understand what you're doing, and the
Yeah.
truth is on our side, how can we lose except through a judge like Heck? Judge like Heck,
Yeah,
right? That
and-
really fits, don't it?
Yeah.
Okay.
Well, it's Jedburgh Justice by Heck.
Yeah, judged by Heck. So, Judge Heck got off the stand not once, I understand, but 3 times. Okay? 3 times, Jim, because she frankly did not know how to handle him. So what happened next then, Kevin?
Well, the judge turned and looked at the lawyer, and at that point, the lawyer again wanted to enter evidence, stating he had a document alleging $1,800 owed for the account. So the lawyer got up and put them on my desk, and I looked at them, and he was ready to introduce them to the judge, and I said I object to these being introduced because the plaintiff is not in court where I can cross-examine the plaintiff. I said, Judge, I can't cross-examine paperwork. And the person from the bank, Chase Bank, needs to be here so I can cross-examine my accuser. So I objected to these papers to the judge, Rule 901.
Specifically, 901 is what?
Authentication.
Right, okay. What is 902 then?
902 is a document that's self-authenticating.
Yeah, such as a government seal.
Yeah, state seal.
Right, something like that. Now, did you raise those issues?
Yes, I gave her all those rules.
And let me ask you this. Did you object in this form here, that, Your Honor, that I object pursuant to Pennsylvania Rule of Evidence 901 and 902?
Yes, I did.
And what did the judge say?
I said, based on those rules, that these papers were not admissible to be introduced as evidence.
Let me ask you this. What was document 1?
Document 1 was like an affidavit from a woman, supposedly from Chase Bank. It was a copy
Okay.
stating that I owed so much money.
Now, everybody listen to this. That document, did it state with specificity what documents had she physically examined?
Not that I remember, I didn't see anything other than stating,
All that she said now is that I have firsthand knowledge, and that's basically it, right?
correct.
People. But to have a proper form, they have to state what exact documents that they have examined, and to make the affidavit valid, they have to attach a copy to the affidavit. Was there anything attached?
No, just
No. Okay. So what was the second form now that this guy had that he was trying to use in court?
It was another document stating from the bank that I owed so much money, and there's figures on there.
And what was that?
I
Was
didn't.
that a statement of account?
It probably was, but I can't be for sure.
Did this form that have at the top of it a statement of account?
I don't remember saying that.
And did it state in there a fixed amount of money that you owed this bank?
I believe it did.
Okay. And was this thing, or was this form that here in compliance with Rule 1002?
No, not at all.
And what is 1002?
It's
Let the people
basically
know.
that original is required, and this was just a copy. And I can say that a defendant can say that I have a question about the original,
Right.
the authenticity of it.
And was there a doubt in your mind that it did not comply with Rule 1002?
No, there's no doubt in my mind.
Was it a copy?
Yes, it was a copy.
And did you examine the backside of that? And what was on the backside of this copy?
No, I didn't examine the backside.
But it was the statement of account. More than likely, it would be a blank sheet proving that it doesn't comply with Rule 901 and or 902. Now, did you